Okay guys, welcome to my channel. So today we shall be talking about formation of contracts. Before a contract can be formed, there must be what is called in the law of contract consensus ad idem, that is a common understanding. However, the law is right that before a contract can be formed, there are certain elements that must be in place, such as an offer, acceptance, consideration, intention to create legal relationship, and capacity to contract. So what is an offer? An offer is simply an indication or a proposition made by one party called the offeror to another party called the offeree that he is willing or ready to enter into a legal relationship with him or her, and that this legal relationship will be binding on them upon acceptance. Now, the court, in the case of Khalil and Carbolic Smokeball, define an offer as a clear, definite, and unequivocal promise made with the intention that it shall become legally binding upon acceptance. Now, there are basic terms that a law student or a student of contract should be acquainted with, such as the term offeror and offeree. An offeror is the person making the proposition, whereas an offeree is the person to whom the proposition is made. Now, there are certain characteristics or features of an offer. Number one is that the offer must be certain, it must be precise, it must not be ambiguous or vague. For example, I might sell my car for the sum of 200 million. Is not an offer. However, if you say I want to sell my car for the sum of 200 million naira, that is a definite offer, right? So number two, the offeror must be willing to be bound by that offer, right, upon acceptance. For example, an offeror making an offer must be willing that if this offer is accepted, I will be bound by it, right? An offer must be communicated, right? You don't expect a person to accept an offer that is not communicated to him, or a person who an offer was not communicated to cannot accept the offer, right? It was vice versa, right? Then number four is that the offer must be capable of acceptance. It must be capable of acceptance. Like in the scenario that I mentioned, in the first scenario where I said that, where I gave an example, I might sell my car for 200 million. That is an unacceptable offer, right? You cannot accept such an offer. But I will sell my car for the sum of 200 million. That can be acceptable, right? It can be accepted. Now, there are different types of offer. We have express and implied offer. We have general and specific offer. We have bilateral and unilateral offer. We have a standing offer. Now, let's begin with express offer. Of course, as the name implies, it is an offer that is made explicitly, right? Whereas an implied offer is an offer that is derived from the conduct of the parties. For example, you stand on the road and stop a vehicle. On getting to your destination, the law implies that you pay the driver or the conductor, as the case may be, right? We have general and specific offer. Now, a general offer is an offer made to the entire world. For example, the offer made in the case of Khalil and Carbolic Smokeball, where Khalil accepted the offer by her performance, right? Whereas a specific offer is an offer made to an individual, made to a particular person. For example, A makes an offer to B. A makes an offer like, I want to sell my house to you for 200,000. B can accept the offer if he likes, right? A unilateral offer is an offer made in exchange of an act, right? For example, if A lost his dog and A makes a promise that whoever finds this dog will be rewarded $100. If B goes ahead to find the dog, to search for the dog, and he finds the dog and brings the dog to A. A has made an offer and B has accepted that offer by her action or performance, right? We have the bilateral offer, right? Bilateral, exchange of promise. So as the case may be, in a bilateral offer, A makes a promise to B and B makes a promise to A. That's bilateral, right? That's a bilateral offer. Now, we have a standing offer, which is the last in this category. It is an offer that lasts for a long period of time, right? Once a standing offer is made, it can last over a long period of time. Okay, a student may ask, what is the difference between an offer and invitation to treat? These are two different things. An offer is capable of acceptance, whereas an invitation to treat is not capable of acceptance. For example, in an advertisement, a company, let's say a vehicle producing company or a transport company, wants to order for 1,000 vehicles, and then they now make an advertisement on, let's say, AIT, ROS TV, or any radio or television station. Now, that advertisement is not an offer, it is an invitation to treat. The company that submits their tender is the one now making the offer, right, which they may or may not accept, right? For another example is the display of goods on a shelf. If you go to a shop and goods are displayed on the shelf, the person making the offer is the customer that approaches the shelf to pick the goods he wants and moves to the counter, right? Moving to the counter and making payment, he has made an offer which the cashier will not accept, right? That is a pure example of an invitation to treat. And what are the ways by which an offer can be terminated? Number one, an offer can be terminated by revocation, withdrawal by the offeror. Number two, an offer can be terminated by rejection by the offeree. Number three, an offer can be terminated via lapse of time, right? Number four, an offer can be terminated via death of the offeror or the offeree. Number five, an offer can be terminated via failure of a condition, right? Maybe there is a condition precedent. If that condition is not met, an offer can be terminated. Thank you very much for watching this video. Please like, subscribe, and hit the notification bell so that anytime I release a video like this, you will still know about it. Thank you very much.